recognition and enforcement of decisions issued by courts of other member states under the Brussels I recast regulation. The Brussels I regulation simplified the formalities for recognition and enforcement of any judgment delivered by a court in one member state, the member state of origin, in another member state, the member state addressed. The regulation introduced a straightforward and uniform procedure for the declaration of a judgment as enforceable in another member state, also known as exequatur procedure. This has been taken a stage further in the Brussels I recast, which has abolished the exequatur procedure altogether. From the 10th of January 2015, it will no longer be necessary for a judgment creditor to apply for declaration of enforceability. They can apply directly to have the judgment enforced. Recognition. According to Article 36, a judgment given in a member state shall be automatically recognized in the other member states without the requirement of any special procedure. Recognition can only be refused in very few exceptional cases, of which the most important case, in terms of legal practice, is the one regulated by Article 45(1)(b, with regard to judgments given in default of appearance. Enforcement. As noted above, the Brussels I recast has made a significant change in the procedure of rendering a judgment granted in one member state enforceable in another. Instead of the party wishing to enforce the judgment creditor having to apply for declaration of enforceability, such a judgment will be directly enforceable in the other member state if certain documents are produced. A judgment creditor wishing to enforce a judgment requests the court of origin to issue a certificate confirming the enforceability and giving details of the judgment. The certificate and a copy of the judgment are then sufficient authority for enforcement in the member state addressed. In addition to empowering the judgment creditor to enforce the judgment in the member state addressed in accordance with the law of and under the same conditions as a judgment given in that state, an enforceable judgment carries with it the power to use any provisional, including protective, measures in accordance with the law of the member state addressed. If a judgment contains an order not known in the law of the member state addressed, the order is to be adapted to one of equivalent effect in that state. Refusal of recognition and enforcement. Recognition may be refused if there is a ground for refusal of recognition as referred to in Article 45. A judgment will not be recognized. A. If such recognition is manifestly contrary to public policy, ordre public, in the member state addressed. B. If, in case of a judgment in default of appearance, it is shown that the defendant was either not served with the document which instituted the proceedings, or with an equivalent document in sufficient time and in such a way as to enable him to arrange for his defense, or C. It conflicts with the rules of exclusive jurisdiction or the special rules on matters relating to insurance or consumer contracts. In all other cases, the court of the member state addressed must accept the findings of fact regarding jurisdiction made by the court of origin and is expressly forbidden to review the jurisdiction of that court. Article 36 states that under no circumstances may a foreign judgment be reviewed as to its substance. Any interested person may apply for a decision that none of the grounds for refusal of recognition apply to a particular judgment. An application may be lodged by any interest party against recognition and by the judgment debtor against enforcement before one of the courts listed by the Commission for the purpose. It relates solely to enforcement of the judgment, not to the merits of the case. In addition, the judgment debtor can apply to the court for refusal of recognition or enforcement of a judgment on the basis of one of the grounds for refusal of recognition. The decision on the application for refusal of enforcement may be appealed by the parties in a special procedure. Enforcement of authentic instruments and court settlements. Under most legal systems of the member states, It is possible to express obligations to pay money or perform other types of contractual obligation in an agreement or other document drawn up by a notary or in some other way given public authority and authentication. For example, through registration in a public register or in the court. Such an agreement or instrument is known as an authentic instrument. Under the previous provisions of Brussels I, if such an instrument was enforceable in the member state of origin where it was drawn up or registered, it was directly enforceable in all other member states under the same conditions as a judgment. This has the obvious advantage of being a relatively swift and straightforward way of securing the payment of money or performance of other obligations, since such an authentic instrument can be enforced directly once the creditor has obtained a declaration of enforceability. The only ground on which enforcement could be opposed is if that would be manifestly contrary to the public policy in the member state addressed. Under the Brussels I recast, as a result of the abolition of the need for declaration of enforceability, all the creditor needs to have is the instrument itself and a certificate issued by the competent authority, or, as the case may be, the court in the member state of origin. There is also included in the Brussels I recast a definition of authentic instrument. Similar provisions as those for the enforcement of authentic instruments apply as regards court settlements.